Today's program is Ethics for Patent Attorneys and Patent Agents, featuring Stephen A. Nielsen. Based in Larkspur in Marin County, California, Stephen A. Nielsen is a U.S. registered patent attorney with many years of experience in patent procurement and in achieving favorable results in federal court in the field of intellectual property litigation. Mr. Nielsen is the past chairperson of the Intellectual Property Section of the Marin County Bar Association. He received his J.D. in 1987 from Bolt Hall, University of California at Berkeley, and also holds a B.A. in Computer Science. He may be contacted at nielsenpatents.com, that's Nielsen patents.com, or his email is steve@nielsenpatents.com, and his telephone number 415-272-8210. And now we'll turn the program over to Steve Nielsen.
Bob, thank you for that gracious introduction, and thank you all for joining us here today. As Bob stated, my name is Steve Nielsen. I can be found very easily on Google. If you type in Marin County Patent Attorney, I come up first, second, and third. Today we're going to talk about ethics for patent attorneys and patent agents. The ethics for patent attorneys mirror many of the ethics requirements for attorneys who aren't patent attorneys. People often ask me, what's the difference between a patent attorney and your, quote, normal attorney? And the answer is that only registered patent attorneys can file patent applications for other people with the patent office. Any attorney can, in theory, become a patent attorney. You just need to have a science degree and pass an exam of a day or so, and learn about 5 inches worth of interesting rules from a book called the MPAT. What is the big picture with respect to ethics for patent attorneys and patent ethics? I always like to go to the black and white rules. The best place to start is the local state bar rules. For all of us attorneys, you're admitted to practice in one state or another. I'm admitted in California and reserve my time in Nevada. So I'm inactive in Nevada, but active in California. So I study the California state bar rules. Everything is there in black and white, and the 300 series seems to have the most interesting rules for general attorneys. But we're going to focus on what's applicable to registered patent attorneys and patent agents. So the first thing for a patent attorney, look at the local state bar rules to see what the rules are. Hopefully you've done that in any event to get your license in your state. But again, it's a great place to start. Then the second place is in the Code of Conduct contained in Federal Code of Regulations, Title 37. These are, again, black letter rules of law that mirror many of the rules of your local state bar, but they do have rules peculiar or special to patent attorneys and patent agents. Now, when you talk about the big picture, I'd be remiss if I didn't talk about those who have no moral compass, no real rules, and people who you will see on a monthly, weekly basis if you deal with inventors and companies in the patent world. And I'm talking about invention promotion companies, many industrial designers, and many sort of patent helpers. You might find them on Craigslist. You might find them just locally, people who cater to inventors and offer a world of services, including often, interestingly, help in preparing patent applications. They sort of cross the line of, I think, practicing patent law without a license. They're to be watched, and throughout this presentation, you'll see them sort of weave in and out of one's life, and we need to be aware of them and understand the seduction of some and the danger of all of them. I'll just say for now that they lack any moral code of conduct. As attorneys with our local state bar, we have the state bar rules, as I mentioned before, the big ones include a duty to maintain client secrets. That means don't spill your guts out. Hold client confidence very carefully, especially with inventions. You don't want word getting out that you're being loose with the client's secrets. The other big rule is to maintain a client trust account. Often, if you're, I think, smart and diligent, before you take a project, you obtain a retainer. You put the retainer in your state-approved client trust account. In California, it's called an IOLTA account. It's registered with the state bar. The interest goes to the state bar, and if anything were to happen to you, the state bar seizes control of the account and refunds the money to your clients who didn't receive the services because you weren't around to perform them. So it's very important to maintain the client trust account and to maintain very careful accounting practices and accounting records, and we'll go into that in further detail. The other important idea is a duty to address actual and potential conflicts of interest, and we'll see this later in the presentation when we talk about representing joint inventors. And more commonly, it also comes into play when perhaps you have clients with similar inventions. At what point do you realize that the similarity may cause a potential or actual conflict of interest? And conflicts are to be necessarily avoided, but they're to be acknowledged. And in general, one can obtain waivers of actual and or potential conflicts of interest from clients so long as you follow the format in the state bar rules, allow the client to seek independent counsel for such a waiver of a conflict. And it's good to embrace conflict, because if you have conflicts in the subject matter, it means you become an expert in the field, and new clients and old clients may appreciate your efforts and may not have a problem with you representing others in somewhat the same field. Clients tend to like their patent attorneys, want them to do well, and often consider that a viable option. In the Code of Federal Regulations, we have the Disciplinary Rules, and then we have something called Canons, spelled with two N's, as Bob often has to remind me, and they're statements of general terms of standards of conduct expected of practitioners with the relationship in the public and the legal system. And they're more general platitudes, maxims. They aren't binding, but they give a good moral compass, and they're often very entertaining, just as studying maxims of equity was very entertaining in law school. So these are just general, hopefully to you, common sense statements, and they provide a guidepost. On the other hand, the disciplinary rules are mandatory, and they provide the rock bottom rules, a guide of minimum level. And if you take any ethics class anywhere, they talk about the disciplinary rules. That's the minimum. You can certainly hold yourself to a higher standard, go beyond the minimum. And I think if you do, your practice will flourish. People are very seduced by honesty. For example, if you have an honest auto mechanic or a dentist, you tend to stay with him or her forever, because you develop a level of trust. You don't want to change your service person or representative. In other words, canons are statements of what we should do. Disciplinary rules are statements of what the practitioner shall do or not do. The canons are also well found in the MPAP, that's the Manual Patent and Examination Procedures. In the old days, everybody would have this 5-inch thick tome in their office. Today, we all keep it by PDF on our computer files, and it's good reading. And if you have a copy in front of you, it's good to follow along. Here's one of my favorite canons. In an hour, we're not going to go through every canon, every rule. I've just pulled out the ones that are most meaningful to patent practitioners and patent agents. Canon 10.21, a practitioner should assist, again, not mandatory, should assist in maintaining the integrity and competence of the legal profession. What does that mean? I think we have to add our own color to that statement. To me, it means you're going to maintain the integrity and competence of the legal profession. If you want to be competent, you got to take care of your own health. and you have to do your work like you mean it. It means you have to put some effort into it, show up to work, and act like you mean it. It's also important to tell the truth for a lot of reasons. Also, you'll find the more truth you tell, the less you have to remember. Money, considered a grubby fight over money. In the law practice, a lot of really competent lawyers get in trouble over money issues, usually just from quasi-innocently commingling their own money with the client money. One school of thought is to have one bank for your operating account and another bank for your trust account. In modern times, I question that. Banks are a lot more competent than they used to be. There's an efficiency to having one bank, and in recent times I have yet to see real problems with using the same bank for your operating account and your trust account. I think reasonable minds could differ, but in the last 5 years I've changed my mind. I'm more open to having my trust account in the same bank as my operating account, and again, from what I've read, I haven't seen a problem with it. And you certainly gain efficiency with the moving your checks to the bank, and in a lot of your accounting and your bank feeds, if you use QuickBooks, there is an efficiency in keeping your trust account, your operating account, and other accounts in one bank, especially the more modern banks that offer the bank feeds and automatic downloads into your QuickBooks or other accounting software. In general, hopefully we all know this, the money in your operating account is money you've earned, and from there you pay yourself. Maybe from there you put it into your personal account, take draws into that, and from that operating account you may want to pay your business expenses, such as your rent, your malpractice insurance, your premises liability insurance, everything else, for easier accounting at the end of the year when your CPA does your taxes. So an operating account, money you've earned, you pay your business expense from that. Your client trust account, money you have yet to earn, and the money that goes in and out of the trust account is a bit more careful in that you don't pay your expenses from your trust account. Once you've earned money from the account, it goes into your operating account, and then from your operating account you pay your expenses. So in general, you have relatively few checks going in and out of your trust account. One exception is that when money, say you want to return a client's money, so you decide to not take the job, the client's just too crazy for even you to deal with, or you've done half the work and you want to just return his money, that money can come straight from the trust account, provided you do the accounting. The rules for client trust accounts are voluminous, but in general, you want to use, say, a QuickBook program that always shows accounts for every cent in your trust account and to whom it belongs to. And I'm a big fan of QuickBooks. It takes a long time to set it up and to find somebody who actually deals with attorneys. You think this would be trivial, but when you start doing accounting for yourself or having it done, it takes some effort to find a QuickBooks professional and or a CPA who is familiar with attorney-client trust accounts. Again, I thought it would be very easy, but both myself and other patent people have had trouble finding people very familiar with dealing with attorney-client trust accounts. Don't delegate too much control over your bank accounts. From my reading of the cases that come out, we've all read the cases about the secretary trusted for years, gets into money problems, and then wipes out the lawyer, wipes out trust account, and the lawyer's bears responsibility and risks disbarment, not the secretary or bookkeeper. So my advice, for what it's worth, is to do a lot of the banking yourself. Write your own checks in and out. You can have a secretary or QuickBooks professional or CPA prepare the paperwork, but I wouldn't delegate the check writing to a bookkeeper. It just doesn't make sense. The temptation is just too much for them to easily steal all your money. And I would keep hands-on your QuickBooks account, at least in the beginning, so you know how it's done, and then maybe delegate a bit of that to your QuickBooks person and or enrolled tax agent. But always write the checks yourself. And it certainly doesn't hurt to go to the bank yourself, deposit your checks, and look at the balances that the teller will give you on the deposit slip, because you just can't afford a mistake with your money, because you can only lose your reputation once. And if you have a failure in your trust account, the state bar is going to be all over you, and it's going to be bad for all involved. So you owe it to yourself, you owe it to your clients to be very proactive with your bank accounts. Again, deposit the checks yourself, get the receipt from the bank teller yourself to reconcile that in general with the amount of money shown in your QuickBook program or other accounting program. Here's some other issues that come up that are a bit more philosophical, but they're definitely worth thinking about. A practitioner should assist the legal profession in fulfilling its duty to make legal counsel available. To me, that pertains to more of the criminal law cases where we all have arguably a right to counsel. But does that really apply in the world of patents? Aren't our patents more of a luxury commercial item? Is there a duty to make patent counsel available to all? I don't think there is myself, and I may get some bad email for that, but just thinking about it, I don't see the patent world as really applicable to fulfilling the duty to make patent counsel available. Again, you can write your email to me on your own thought on that. In general, making counsel available means to show up for work, return phone calls and emails, to keep your head in the game, to stay engaged, and to stay active with your clients. The biggest complaint clients have of their attorneys is that they don't communicate and return phone calls and email. It may seem trivial, but it's very important to do so. Sometimes we forget that we're in a special position to help our clients, and they're waiting for us, and they really can't do any of this themselves. So we have to maintain our empathy and realize we're really have a very humbling responsibility to our clients. With respect, again, to making legal counsel affordable, if someone comes in or calls you on the phone and they need help, patent help, or any kind of help, a safe referral is your local county bar association attorney referral program. I've read that there's no theorem of negligent referral if you refer someone to a state or county bar association referral program, and that's the best way to go. And these programs can often help people find the right person, but there is a danger of negligent referral to, say, private sources. So a good way to go is to make sure that you refer people who are known competent to you and don't have any problems. And the very safest bet is, again, to refer people to your state or county bar association referral service. A practitioner should assist in preventing the unauthorized practice of law. This is something I truly believe in, and without being a vigilant ante, I do what I can actually to stop this. If you look at Craigslist or its newest counterpart, Backpage of all things, you may find listed what I would call a local patent helper, or I might also call them a patent butcher. People preying on inventors and trying to part them for their money, and they're pretty effective at it. I know the invention promotion companies have been around for years and years. They're going as strong as ever. They'll get shut down by the government, and they pop up in a different form, and they're back at it. And we need to be very careful to not assist in the unauthorized practice of law. So to me, that means if you're approached by an invention promotion company and they want to send you a lot of clients on a lot of work, I would say no, and I have said no, because you're going to end up aiding the unauthorized practice of law, because inevitably they'll try to share fees with you, they'll try to become a large portion of your book, and they'll try to influence you. These companies will want to, quote, partner with you, and it's just a road to disaster. And I've read many cases where a lot of hard-working patent attorneys are approached by the invention promotion companies, and the practice turns into something that's not authorized. So again, if you run into these people, or if they're referred to you, or they want to work with you, I would just simply say no and move on. sharing of fees is not allowed under the rules and canons. And in the world of patent procurement, it's very difficult to legally share fees. It's especially illegal to share fees with non-lawyers. And this means no referral fees from invention promotion companies, no partnerships with non-practitioners. And unlike personal injury cases, it's very difficult to legally share fees in the work of patents. And it's just something you just really can't effectively do. We need to protect the secrets. This is a shall, it's a rule. And the issue is, what standard of care do we have to follow in maintaining client secrets? And we have to define what is a confidence. A confidence is something that would be embarrassing to the client. It would be detrimental to the client if it was exposed to the public. I protect all client information, and I use reasonable care to protect the confidences. And reasonable care, as we know from our first year of tort class, changes as technology changes and as our world changes, and we need to keep up with the world. We're living in 2015, 2016, not 2005, and we need to think about the cost versus the risk versus the benefit versus common practices in light of new technology, in light of the ease of the technology. And so there's no real black and white book we can read to say, well, what is reasonable care for maintaining client confidences? I suggest we all stay up on technology and use the tools that are available to us. Here in 2015, 2016, we have a lot of tools. Some, I think, have never taken off well, such as encryption of hard drives, encryption of email. We've been able to do that for 15 years. It's very bulky, difficult to do. I'm not sure if the standard of care requires that. I think there are reasonable efforts that meet the standard, such as locking down computers with passwords, physically locking file drawers, and password protection for documents. For example, you can send a client a sensitive document, have it password protected, and then follow up with a phone call with the password. That way, if it's intercepted, someone will have difficulty opening it up. If you have sophisticated clients, it's certainly fine to use encryption, but again, there's a level there that's difficult, and email encryption has yet to meet the grandmother test where it's simple and easy to use. Another newer trend for 2015-2016 is a secure login system for client communications, akin to what you might see in Kaiser or another healthcare provider. I've seen services out there that seem to be a reasonable price, where you set up a server, which just means the fancy word for a computer hooked onto the internet, where you can log in and a client can log in, and you can exchange messages there on the server. In theory, they don't travel so far over the internet, and requires credentials to get onto the login system, sort of like, again, what Kaiser does. And that might be something that's reasonable and not too expensive and not too cumbersome, so that actual clients and attorneys might use it. So that's something to keep in mind as we move forward from 2015, a secure login system, and there are many vendors doing this now for a reasonable price. Here's one of my favorite rules. A practitioner may not use a confidence of the client to the disadvantage of the client or to the advantage of the practitioner. How does this result in our world? The practitioner, the patent attorney or patent agent, should not become a co-inventor. Not a good idea. This often comes up when a client who comes to a patent practitioner, and let's say it's a field that the patent practitioner has been doing for 15, 20 years, and he or she knows the area well, and the client comes in with a great invention, and the practitioner sees some things to do to make it even better. The practitioner doesn't want to jump in there and be a co-inventor. One honored method is to use the Socratic method to pull the information out of the inventor, lead the inventor to derive this improvement themselves. And if you ask the right questions, this will happen, and it's one way to avoid being a co-inventor. Another important rule here is to not use inside information to buy stocks in a company. It may sound trivial, but there was a case in Oakland where a quite successful patent practitioner lost his license. Over $10,000 he made trading a client's stock. It was just dumbfounding. But so I mention it here. In other words, don't use the client information for anything outside of drafting a patent application or representing the client. Canon 5 and the corresponding rule 10.62, a practitioner may not accept employment that may affect the practitioner's own interests. In other words, a practitioner should exercise independent professional judgment on behalf of the client. And this, again, pertains to the invention promotion companies that do approach patent practitioners and will attempt to affect your judgment, ask you to do a lot of design patent applications, maybe ask you to add some ornamental flares to an object with your own drawings. There's actually case law on point where this happened, and a lot of design patents were filed where the practitioner added some ornamental flares to get the designs through. And that's definitely a case where the invention promotion company skewed the judgment of the patent practitioner. So that, again, is to be avoided at all cost. Limiting business relationships with clients. As a patent attorney, every day I have an opportunity to invest my time and effort in a client's business in exchange for my services. Clients feel it's their duty to ask, and I used to get offended, but now I realize just it must be in some business book somewhere where startup companies are required or feel the need to offer equity in exchange for services. So don't be offended when it happens, but it makes sense. You just have to respectfully decline for a lot of reasons. If you were, say something was truly exceptional and you wanted to just think about this, you'd have to make full disclosure and allow the client to review the proposed agreement by separate attorney hired by the client. A lot of clients don't want to hire separate counsel, but that's just one of the rings you would need to go through to do this. And again, it's a tough idea. It's not going to work most of the time. I think the best practice, if you're going to do a contingency fee litigation, which is more acceptable, is to have the client find separate counsel to review and approve the written agreement. The rules require that the client be allowed the opportunity to engage in separate counsel, but if you're going to do contingency fee patent litigation, I would insist that the client actually find separate counsel and have the agreement approved as to form, because if you make it big, the client's going to want to try to pay less just inevitably. Then the other sort of practice pointer I have, sort of hammer this home, about clients wanting to give up a percentage of the company for you to do their patent application, is you'll hear these sort of pleas. Please be our hero. This invention will change the world. And you'll hear all these great platitudes, and inventors generally do believe these things. But I think before you start your day, you want to have a mindset as to where you want to go with your practice, what your needs are, and also what's going to happen downstream if you do take a percentage of a client's business in exchange for services. And also the very real possibility that if you get the proper disclosures, lengthy agreements approved by outside counsel, you get the opportunity to work for free and never get paid. Think about 30% of nothing. Okay, if the invention is not worth the inventor's personal money, is it worth your time? And also downstream, after the agreement's signed, do you want to keep tabs on this inventor? Do you want to keep track of what they're doing? Or do you really think that if they make it big, they're going to just start writing checks to you? But more typically, during the months after you were to file a patent application in exchange for equity, wouldn't the inventor be calling you on an ongoing basis for any kind of advice? Say they want to get a will done, they're going to ask if you do that. They're going to feel that they own your time from then on, and they're not going to be shy about calling you all the time about everything. Now, and also, people don't value what they get for free. And when you get these opportunities to take equity in a client's invention, I would just say no. Take your kids to the library, spend your time and effort there, and move on. Competence. A practitioner shall not neglect a legal matter entrusted to the practitioner. This is the biggest problem that I see when I inherit a file from a patent attorney who's just given up. We need to show up for work and report news to the clients. So a lot of problems are acts of omission and really not doing the wrong thing, but just not acknowledging an office action that comes in or keeping the client advised of what's going on in the patent office with a patent application. It's very easy to report the bad news from the patent office. It's good to have a practice of reporting all communications from the patent office the day of the communication, and one can just communicate and say, this came in from the patent office, it says X, let's discuss it later. Some patent attorneys feel they need to look at every piece of prior art, come back with arguments. If you do that, you're going to procrastinate. You're not going to get out the bad news the day that it comes out. So just make a mental note and a practice that you get your private pair announcements about an office action, you get the office action out and say, let's discuss it later, and also give the timelines to respond, and that's enough to initially get the news out so you don't procrastinate. And if you do that, you'll stay on top of the curve and you won't be flooded with past due office actions. Disclosing adverse legal authority. This sort of dovetails in with responding to office actions in the patent bar, and also in the patent bar we have a duty to disclose positions that are against the client, and this comes into the play of we have to disclose known prior art in a pending patent application that is adverse to the application. We all know this, and it comes up in responding to office actions. So it's unlike other areas of law where there isn't a duty to disclose adverse authority. We do have that duty. We need to keep advised of it, but also in a way it's to our advantage, because if you know the adverse authority, you can deal with it, disclose it, and attempt to distinguish it from the subject patent application. If you do that, you're ahead of the curve and you've done your best and you have less to worry about. Everyday issues for patent attorneys and patent agents. Surprisingly, if you practice more than 5 years, you're going to end up with something that is perpetual motion. Clients find ways dealing with air bubbles or water bubbles or something where they take energy stored in one state and use it to do some things and then attempt to put that energy back in the first state. Obviously, that's perpetual motion. You won't see perpetual motion directly described, but when you kind of look at it, you can see it. What's interesting about perpetual motion is that it's the only type of invention that requires a model to be sent to the patent office. For many years ago, for many years, a patent application required a scaled-down model. For example, when Abraham Lincoln did his patent application and subsequent patent for a buoyancy device for a barge that involved the filling of barrels with water and air, he had to make a little model of it, and that was for every invention. Well, that's been dropped. In fact, if you go to older patent law firms, they'll still have the little models there. But today, no models are needed except for perpetual motion, because the idea of the patent office is that you go ahead and try to make a model, you'll never make it work, and you'll save us our time. So you need to recognize perpetual motion and never claim it as that, and tell the client that if you want to claim perpetual motion, you have a very tough road ahead of you that requires the construction of a model. One way to think about it is a system, and disclaim perpetual motion if the client agrees to that, and maybe there's some mechanical genius even without the perpetual motion aspect. Here's a good question that comes up all the time. Inventors will ask, do I have to build the invention first? And the good news is that inventions may be prophetic are on paper only or in the future. And what we're required to do is, in a patent application, disclose the invention with enough detail such that one reasonably skilled in the art can make or practice the invention. And it's often done through drawings. And what's really interesting here in 2015 and forward is that the client drawings have gotten 1,000 times better than they were in the past. There's programs called SolidWorks that clients use, or often industrial designers will use, that provide beautiful drawings, and then they also get keyed into their CNC machine, or computer-controlled machine, that actually cuts out the device, sort of, and they're also used in 3D printing. So describing an invention is much easier today than it was in the past, and the advent of the much better drawing programs such as SolidWorks makes that much easier today. An invention doesn't have to be perfect. Clients will ask, well, or they'll try to prove to you what the greatness of the invention. And I try to save everybody's time and tell them, you don't have to convince me of the order of magnitude of improvement of this invention. As long as the invention operates, can work, and you can describe it such that one skilled in the art can make the invention, the utility of the invention just has to be better than landfill. So we aren't looking for greatness here. And this landfill is one of my favorite cases. There was a patent case involving a semiconductor chip. Didn't work. And the patent practitioner argued, well, it could be used as landfill. And the court said, no, you got to be better than landfill. So that's always stuck with me. So you don't need to spend a whole lot of time with your client letting them convince you of the greatness. It's just got to work. So you have to think about what's important, what you need to know, and be somewhat stern in directing the conversation with the client, because you want to be efficient with everyone's time. Inventor conflicts. This happens all the time. Often there'll be co-inventors or people who think they're co-inventors. I want to think about Facebook as a good example. And whenever you have more than one person involved in a project, there's going to be conflict overall. And this comes in very different ways. Fortunately, the Patent Office, they're ready for this. This has been going on for years. The Patent Office, they're very good at dealing with inventor conflicts, and it's the only area that really addresses insane inventors and dead inventors, mostly insane inventors, which is comical because in normal life we don't run a law into many people who are considered insane or who go insane during the patent process. So the first inventor conflict we have is a non-signing inventor. Let's say two people purportedly invent something. One inventor says, hey, I don't like my cut here. I want out. But in order to have a valid patent application, all of the known inventors need to be named and sign. And if they can't sign, you need to file a petition to excuse their signature. And it's not that difficult to do. The rules are very careful, and if you follow them to the letter, you'll be okay. The most interesting rule is that the application has to be mailed to the last known address. You have to have someone swear that this is the last known address, they've received mail there. And if you do all this and you pay the filing, the petition fee of a few $100s, the Patent Office, they're very quick to grant these petitions. It's really not the problem that it is the first time you deal with it and you see it. The Patent Office are quite used to this, and dealing with a non-signing inventor is not that difficult. Now, what happens when inventors part ways and you're representing both inventors? Often you may get a case where a husband and wife invent something and then they split apart. Who do you represent? Who do your duty of loyalty goes to? What I suggest in joint inventions, invented by joint inventors, you have them sign a waiver of conflict of interest akin to what family law lawyers do when they represent both a husband and wife in a divorce proceeding, and that you acknowledge that they're both coming to you for an economy of scale, and that if you can't hold one competences over another, and what conflicts are waived between one another, and if you deal with it ahead of time, you'll be much better off. And it's just a few paragraphs that you can add to your fee agreement to deal with this inevitable fact of life that co-inventors are going to part ways, and not want to cooperate with one another. So something to deal with up front. When I first started practicing, I had a buddy who worked at a large law firm and asked him what he did, and he checked it out, and his answer was, well, we just don't take joint inventors. We only represent corporations. And that's a draconian approach. It isn't going to work for many of the smaller patent law firms. So it's something to embrace, to deal with, but it can be dealt with artfully with a joint representation agreement. Insane inventors, get used to it. This dovetails into maybe representing older inventors who come in and have an idea. I've had some older inventors who come in referred to me by lawyers, and I've called the referring attorney and asked, is this person competent to move forward? And to my surprise, they've said, yeah, he's fine. And then, so I move on. But I'm always careful with elderly inventors. Are they competent to move forward? And you need to be careful of that. And this sort of raises an issue of, if you see somebody just seems to be not competent, do you have a duty to disclose that to the local authorities? Maybe they're a danger to themselves or others, and I'll let you ponder that on your own. An analogy could be, if you see somebody driving and they're swerving, you report that. On the other hand, if somebody's your client and they don't seem to be quite competent, what do you do? That's a whole other ethics tape, and there are whole areas of field and elder law that deal with this very interesting issue. This is what I call the pet rock issue. Every day you will be asked, what do you think of my invention? And clients ask that. I don't know, some are looking for validation that it's mechanically brilliant, that it's going to be commercially successful, and I would be kind to them and have the question rephased to deal with patent issues. One of the things that I tell clients all the time, they get tired of hearing this, is that as far as commercial success goes, how do I know? If I can predict commercial success, I would have bought Microsoft at $5 a share 40 years ago, and I wouldn't have predicted the rise of the pet rock. Of course, now a lot of my clients are too young to remember the pet rock or know the pet rock. So I always come back, if I could predict commercial success, I'd be retired by now. So I can't offer an opinion to that. So again, rephrase the question, deal with patent issues, think about patentability. Is it patent subject matter? Is it new and novel? And the answer there always, it depends. Fee agreements, again, are very important to deal. We talked about having joint representation agreements. We have co-inventors. The rule in California is that a written fee agreement is needed when the charges will likely exceed $1,000. So what can you buy for $1,000 at a patent office? Not much. So pretty much all your clients are going to have written fee agreements, but it's a great opportunity to educate the client as to the facts of life with a patent application. So in your provisional patent application agreement, it's really good to talk about that the provisional has a 1-year expiration date. You have 1 year to file in other countries, and you disclaim any opinion as to commercial success, disclaim your duty to search for prior art, and also you can disclaim a duty to calendar the 1-year deadline. Think about that. A lot of clients get in trouble for calendaring things or miscalendaring. Do you have a duty to calendar? And maybe if you don't want to have that duty, maybe you should disclose that. And for these key points, it wouldn't hurt to have the client initial it and to have these key points such as the 1-year deadline on a provisional patent application to have it to be separately signed on an initial line to initial. And also, fee agreements can also should be used on search agreements. Sometimes a search agreement can just be a 2-page letter agreement, and that agreement can say, we'll do my best, but we don't promise to find any or all of the art, and we can't offer any opinion as commercial success. And also on a search agreement, talk about the fact that patent applications often aren't published until 18 months after their priority date. So in other words, if somebody files a patent application for a pet pigeon, some new invention, we're not going to see it for 18 months. In fact, we may never not see it until it becomes a patent, because you can always check the box, not have it published. until it becomes a patent. So that needs to be disclosed in your written fee agreements for a search for prior art. The fact that many patent applications filed aren't going to be visible for some time, sort of a rolling dark period. Then clients often ask, should I do a search or not? And I tell them there's no duty to search for prior art, but there is a duty to disclose known relevant prior art in a non-provisional patent application. So in a provisional application, the patent office won't even accept an IDS. You don't disclose the prior art, but in a non-provisional utility application or in a design application, need to disclose any and all relevant prior art. The best way to do that is in the form of the IDS that you upload with the patent office as well. That's the best thing. I don't push the searches, but I tell clients that no one's sorry they got to search, because sometimes you'll find something interesting that's helpful. And also, if there's something that's interesting or out there that didn't make it, maybe the client wants to abandon the whole commercial endeavor and save not only the patent application fees, but the whole business fees of setting up their entire business. I tell people with the search that it's difficult to prove a negative in the universe, and I of course credit Carl Sagan for saying that back when he was around. So there are no guarantees with a search for prior art. The other interesting thing about a search is there's no real written standards of care or no real written protocols. The patent office, they have some little written protocol, but I wouldn't call it a real guide. And reasonable minds can differ as to how a search is properly conducted. How does a patent attorney do a search, and how does a patent examiner do a search? In my experience, a patent examiner is very mechanical, and they don't always get it right, which inures to our benefit because we can show them the error in the ways and hopefully get around their office action. But in the fee agreement for a search, you want to point out it's a difficult task, and there's simply no guarantees you're going to find any or all of the relevant prior art. Patent litigation, great topic. In general, any attorney can engage in patent litigation. Only registered patent attorneys or patent agents can file patent applications for another, but patent litigation, that's open to any attorney, and there are special ethical rules dealing with patent litigation that we're going to go through here. As many of you, I imagine, aren't patent attorneys, but maybe you want to do some patent litigation. It's very exciting, it's fun, and it's really a worthwhile endeavor if you have the bandwidth and time to do a great job with it. First thing to understand is that federal court has exclusive jurisdiction in patent matters. I've run across cases where attorneys file patent matters in state court and they actually live there for a while till somebody brings it up and says, hey, this is a federal case, and the state court judge will kick it up. It's rare, but I've seen it happen. So don't embarrass yourself and file a patent case in state court. What's very interesting with patent cases, we have special punishment or patent punishment regarding Rule 11 diligence in pre-filing a patent case. You have to do a pre-filing investigation. So as we all know, Rule 11 in federal court says one will take due care not file false pleadings and be careful. So what are the rules? What's Rule 11 mean in patent litigation? It means that you're going to check patent ownership. You're going to go through the USPTO assignment records and have you accounted for all the inventors. You're going to look to make sure that all the inventors to the application were listed. So you have to do your due diligence, because if you don't do this and you lose quickly, you could be subjected to attorney's fees of the other side. And there has been a lot of case law enforcing more attorney's fees to the losing party in a patent litigation case. Then one of the more interesting parts in pre-filing for a patent case is doing your own claim chart, such as a claim chart you do after your initial case management conference. And in summary, you want to do the limitations of an independent claim read upon the defendant's products. In other words, you do a quick matrix on an Excel sheet or use make a table You have the claim limitations, you have the product, you can check the boxes to see if all the limitations are in the defendant's product. And then the next question is, do you have a duty to obtain a copy of the product? And the answer is yes, if it's reasonable to do so. I'd say if the object costs less than a couple $1,000s, you have a duty to obtain one and to check to make sure that you've got a colorable claim of patent infringement before you file your pleading. Now, every invention is different. Some are more physical than others, but you need to take your Rule 11 obligation very seriously before you file an action of patent infringement. In the pre-claim litigation chart, again, we need to study the product, you need to study the claims with great clarity, and decide the meaning of the words in the claims as you would in a Markman hearing. And that's done in brief summary by looking at the specification, looking at dictionaries, talking to experts in the field. How are the words used with respect to making the invention work? So it's going to be very frustrating. Your client's going to have a certain viewpoint of what his patent quote covers, and you pretty much have to ignore that. You got to study the four corners of the patent application, and you also have to study the file wrapper. For you non-patent attorneys out there, the file wrapper is a file you obtain from the patent office, usually under public pair. Any patent that's been granted is a matter of public record, and its tortured prosecution history is also a matter of public record that you can look up and see what admissions were made in the office actions and what happened in obtaining the patent and what ground was given up in obtaining the patent. So often in the office action responses, you'll see admissions by counsel. Sometimes you just have to make these admissions, no fault of counsel, to get the patent that may and often do narrow the scope of a claim. So when you're doing your claim chart, you read the file wrapper, figure out if your claim interpretation is going to be made more narrow by the ground given up in the office actions and arguments made in the office actions. Got to figure out how does the specification use the term, and also it's interesting to read in the notice of allowance the reasons for allowance, and they often sort of recite the claim terms to figure out why was this invented, and very few lawyers bother to object to the reasons for notice of allowance. Often they're quite correct, but that's something to carefully consider, and those are given weight by the judge. And also we need to figure out words, read them very carefully. One of my favorite dichotomies or differences in the word comprising versus consisting. If I were to say my desk consists of a flat planar surface attached to four legs, that's it. If I were to say my desk comprises a flat planar surface and four legs, it would allow the addition of a monitor, a keyboard, and other objects. When I say comprising, you're allowed to have more on that. So little nuances on that are very special and unique to the world of patents need to be taken into account when you're doing your pre-litigation study. Here are some ethics of pre-litigation practice. Is that an offer of a license may trigger a dec relief action for non-infringement. So in other words, you represent a good client. He's got a patent on a gadget. You find someone who looks like they're infringing, and the client on his own or you in a zealous moment write a very stern cease and desist letter saying, you got to stop this, bad things will happen. Now, in the old days, before the case of the Menemune, one had to threaten litigation or infer litigation before someone had standing to say, hey, there's an actual case in controversy. About 7 years ago, this case of the Menemune came out, which says that if a patent holder is, in other words, harassing, making life difficult, or interfering with the business, a very loose standard, then the person who gets this threatening letter gets to sue for dec relief of non-infringement at a jurisdiction that they can get away with. So in other words, if say you and a client, you're in California, the client's got a great patent, and somebody in New York might be infringing, You write a nasty letter to New York, and let's say your client does some business in New York, enough to warrant specific jurisdiction, specific personal jurisdiction. Your client may end up getting sued in New York on a deck relief action of non-infringement, which means that this person in New York is saying, my object doesn't infringe this, and I filed a lawsuit in New York. You have to come out here and defend this, and I'm going to get a judgment to say I don't infringe. And in that deck relief of non-infringement, the person accused of infringement can also sue for invalidity of the patent, saying this was obtained by fraud, it turns out it's obvious, it's anticipated by the prior art, not found by the patent office, and now your client's got a problem out in New York. So before you write these nasty grams, you've got to discuss this with your client, as you may have the unpleasant surprise of having to defend the validity of the patent out in New York, and if you don't, let's say there's a default judgment and the patent's considered invalid, that's going to be a terrible result for your client. Also, in patent litigation, if you sue on a patent, you have to realize that the defendant can ask the patent office itself for a re-examination and can ask the court for a judgment of invalidity. Now, if there's a re-examination at the patent office, who's going to pay to defend that? Does your fee agreement cover that? Did you talk about that with the client? Is the client going to go crazy realizing now he's got the invalidity at issue not only with the patent office, but in the federal court itself? And does your fee agreement address the cost of the patent re-examination before the patent office? I call patent litigation a meat grinder. Arguably, all litigation is a meat grinder. The defendant's going to have an opportunity to present new prior art to invalidate the patent. The defendant's going to look for problems in the patent owner's 1-year bar on sale issue. So in other words, does the priority date of the subject patent, is it within a year of the patent holder's first offer of sale or public disclosure? So with Google and the time back machine, a defendant can go back in time and see if your client was disclosing this earlier than 1 year from his first filing. So that's something to think about and address before you file an action for patent infringement, and look for evidence of the thing being offered for sale. The last thing I'm going to touch upon briefly is invention, promotion, fraud. Clients will often say, hey, how do I promote this? I tell them no one's going to believe in your business like you, and to avoid invention promotion companies. And if you read the ethics opinions at the Patent Office website, you'll see a lot of case law. There's a company called PTI that charged a lot of money, roped in a lot of registered patent attorneys to do the work, and did them in ethically, and also took in $61 million from 17,000 customers. And the company couldn't have identified one single successful consumer who made more than they spent. So these invention promotion companies, they're to be avoided by the plague of your clients, and I tell every client to avoid them, and I've never regretted that at all. Again, the invention promotion companies will often inflict a conflict of interest with the patent practitioner, and you can read about this in the reading room here on the site on this slide here. Are there any questions from the audience today? Okay, all right. Well, if anyone has any questions later, I'm very easy to find. My name is Stephen A. Nielsen, and if you Google Marin County Patent Attorney, I come up. And my website is nielsenpatents.com. It's Nielsen, patents.com. I'm in Larkspur, California. My phone number is 415-272-8210. And my email address is simply steve@nielsenpatents. Thank you very much for sharing this time with me. And if you have any questions, I look forward to your email. Thank you much.